Okay, good morning.
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 Okay, I'm pleased to announce I have Judge Wallace and Judge Sasso joining me on the panel today. We're here on Parker versus State Farm. You should have a clock on the screen. Can you both see it?
Yes.
Okay, and if appellate's counsel wants me to help as far as warning you when you're getting close to using up your regular time before rebuttal, let me know. How much time do you want for rebuttal?
5 minutes, please.
Okay. And I want to remind you that these arguments are being live streamed so that the public can observe them. Okay. So Ms. Sanchez, you may proceed.
Thank you. Good morning, Your Honors. May it please the court. Alexandra Sanchez with the law firm of Bruni and Rooney. And I'm here on behalf of the appellants, Lori Parker and Dante Agno Fabiani, whom I will be referring to as homeowners throughout this argument. We are here asking the court to reverse the lower court's order, which granted the appellee State Farm's motion to dismiss, or referring to State Farm as insurer throughout this argument. The trial court erred when it granted insurer's motion to dismiss because it failed to confine itself to the four corners of the amended complaint. When this court reviews that order de novo, it should find that the trial court could not have granted the motion to dismiss without making findings of fact outside the allegations contained in the amended complaint. As such, the trial court's order must be overturned. By way of a quick background, as alleged in the amended complaint, homeowners purchased and insurer issued homeowners insurance policy. Homeowners' home was damaged, they made a claim, insurer acknowledged it, and sent Gulf Atlantic to the home, whom I will be referring to as unlicensed contractor throughout this argument. Homeowners signed an assignment of benefits to unlicensed contractor. However, that was alleged in the amended complaint to be invalid. Insurer issued a check made payable jointly to homeowners and unlicensed contractor. Insurer has failed to remit proper payment to homeowners to date, so homeowners have not been able to get their roof fixed, and they were forced to initiate the underlying litigation. Within the amended complaint, we alleged that the assignment of benefits was never valid. However, we never had an opportunity to explain ourselves. Insurer responded in its motion to dismiss that homeowners assigned all of their rights under the policy to unlicensed contractor. However, assignment is an affirmative defense. This should have been addressed in an evidentiary hearing.
Well, let me ask you, the assignment was attached to the amended complaint, right?
Correct.
So did you allege any facts, not just a conclusion that the assignment was invalid to your amended complaint? Other than that, Gulf Atlantic was an unlicensed contractor.
We simply allege that the assignment of benefits was invalid. If the trial court wanted more facts for that, the proper course would have been dismissal with leave to amend to add more facts.
Did you allege that it was invalid or void because Gulf Atlantic was a unlicensed contractor?
No, we simply allege that it was invalid, illegal, and unenforceable. However, I believe that that is a mixture of law and fact. It could have been invalid for 1,000 different reasons, and that should have been determined in an evidentiary hearing.
Well, what was the argument you made to the trial court? Didn't you argue that it was void because it's an unlicensed contractor?
Yes.
Okay.
We did argue that. However, that was only contained in count 2 of our amended complaint, which was dismissed.
But count 2 would have been relevant to what the judge had in front of the judge, because he had count 1, count 2, and then he had the assignment as far as determining standing at the time you filed the lawsuit.
Correct.
Okay. In your argument to the trial court and your argument in your brief, you argued that your contract with Gulf Atlantic was void. Is it still your position that it's void?
We allege that it was invalid, so it should be treated as if it was void ab initio. We never alleged that it was once valid and later became invalid. And I think that's where some of the confusion lies. because I believe that insurer is trying to argue that it was once valid, later became invalid, so then we never had standing until after we got a release from Gulf Atlantic. But within the four corners of the amended complaint, we alleged it was invalid at the time that insurer issued a check to Gulf Atlantic, an unlicensed contractor.
But the court can consider not, the term four corners would include attached exhibits, right?
Correct, but it's not our position that it contradicts. We attached it, we said this is invalid.
And
But you have to
the,
say- But that's, go ahead, Judge Sasso.
the allegation that was invalid, what is your response to the argument that that was a legal conclusion? And so even being confined to the four corners of the complaint, the trial court was not required to accept the allegation that it was invalid and void ab initio, as treated as true for the purposes of evaluating the standing argument.
Well, in order for the court to determine that it was valid, they would have still had to go outside the allegations contained within the complaint. The only way to determine that it was valid is to make a finding of fact that it was valid, and that would require an evidence.
There was an assignment attached, so the determination would not be whether or not it's valid. It's treating the assignment as true for purposes of the evaluation. You're saying to declare it invalid, that there would have been need to be an evidentiary hearing, or to determine the validity at all. I guess, could you clarify that point?
Yes, in order to, so the trial court's correct, contained to the four corners of the amended complaint, which does include the exhibits. However, we allege the exhibit's invalid. We attach the exhibit, we say this is invalid. In order to overcome that, even if the trial court looks at it and treats it as true, it still has to look at everything all together. In
Well,
order to overcome that,
let me ask you this. If the contract, if you have the assignment attached and you just file the lawsuit and you don't allege it's invalid, could the trial court then have properly found that your client lacks standing?
I'm sorry, can you repeat that?
So you file the complaint and you attach the assignment and you don't allege invalid, you don't allege anything about validity one way or the other. Could the judge have then determined that you lack standing because based on the exhibit, you had given away your right to sue to someone else?
I do believe so, Your Honor, and I think
Okay.
that's what this,
So then if you allege it's invalid to contravene your exhibit, do you have to allege facts that rather than just say it's invalid?
I think that goes back to, I believe it's a mixture of law and fact by saying it's invalid. It could have been invalid for 1,000 reasons, and I believe that the proper thing for the trial court to have done if they wanted additional facts would have been to dismiss for leave to amend. Further, insurer didn't file a motion form or definite statement. Those would have been the two proper courses if the trial court wanted more facts.
Did you ask for the opportunity to amend to say you could allege a different basis than what
We
was
did,
in
Your Honor.
count two? Okay.
So
Would an amendment have been futile based on the agreement that was filed, which indicated that the assignment was revoked subsequent to the initial filing of the lawsuit?
no, and I want to point out that I believe is a total red herring. Our allegations before, even if we were permitted to amend, were always that the assignment was invalid. State Farm knew it was invalid, and it was invalid when they issued the check to homeowners and unlicensed contractor. The later
Why are
release,
you arguing it was invalid?
because they were unlicensed.
Because they were unlicensed?
Well,
Okay.
Yeah,
And-
and they also didn't perform any work. I mean, there's
All right,
a
but
number
what
of reasons.
authority do you have to show that it was an invalid assignment just because Gulf Atlantic was unlicensed? As opposed to the fact that Gulf Atlantic, if they were unlicensed, could not enforce the contract.
So this court in Boatwright versus Tar found that where an unlicensed contractor enters into a contract, the contract's invalid and unlicensed contractor can't enforce it.
Well, but
So,
can the homeowner enforce it, for instance?
well, based on the lower court's decision, the homeowner can't. So that's the issue here.
No, I'm
is
talking
that-
about generally. Like, let me give you a hypothetical. Let's say that your client hires Gulf Atlantic. Gulf Atlantic puts on a roof. They get paid for it by the insurance company. The contract you had with Gulf Atlantic said that they would use grade, some high quality shingles, grade A shingles. And then after they put on the roof and then, a little while later, the homeowner sends someone up and finds out they use low quality shingle. So can the homeowner sue on the breach of contract for using a low quality shingle?
I believe so. I believe that homeowners would still have to sue both Gulf Atlantic and both the unlicensed contractor and the insurer.
But that's my point, is how could the homeowner sue on a void contract?
Because homeowners they still need a remedy. And I think that's where it all kind of gets mixed up here. If homeowners did not sue insurer, they could have been tied up in litigation with Gulf Atlantic for 5 years, finally resolved after 5 years, and then the statute of limitations would have run. They wouldn't have been able to sue insurer. I think that it would have been improper to not include both parties. And additionally, I believe that insurer waived its standing argument by making the check payable to both homeowner and unlicensed contractor. If homeowners assigned all of their rights away under the policy, then insurer only had to make a check out to unlicensed contractor. But that didn't happen. They made the check out to homeowners and unlicensed contractor. It's well settled in Florida that where a check is made out to someone, they absolutely have standing and right to seek redress of payment. Insured didn't do that. They made the check payable to both of them. So going back to the allegations contained within the four corners of the amended complaint, homeowners alleged that the assignment of benefits was invalid at the time insurer issued the check. That means it should be treated as if it never existed. That means it should be void ab initio. That means that homeowners never transferred any of their rights under the policy. Because the trial court went beyond the four corners of the amended complaint to make a finding of fact that the alleged invalid assignment was valid, the lower court erred. And we are asking this court to reverse the lower court's decision, to remand this, and to direct insurer to file an answer.
All right, thank you.
Thank you.
Mr. Samus?
Good morning, and may it please the court. This is Scott Samus for the Appalachia State Farm. I think the court hit on the problem with this complaint. The trial court didn't have any choice but to dismiss the complaint because it affirmatively tried to state a cause of action that had been assigned away by the plain terms of the assignment. The allegation in the complaint that this was an invalid or unenforceable contract is an assertion of law. And even in the Siegel case that was cited by both parties, on a motion to dismiss, a court has to accept allegations of ultimate fact as being true, but certainly doesn't have to accept assertions of law being true. And clearly, if that were the case, then we might as well remove the motion to dismiss from the rule book, because you could just say, assert this states a cause of action. I mean, I could have a breach of contract for selling a ton of cocaine and assert that that is a legal contract, and the court would have to accept that legal assertion is true. So the legal assertion that this is an invalid or an unenforceable contract was not, the trial court was not obligated to accept that. So what the judge was faced with was a claim with an exhibit attached, and the exhibit controls over anything that contradicts it, that under Florida law transferred away the cause of action that was being claimed. And the Florida Supreme Court, as well as this court, has looked at assignments of benefits just like this one in Continental Casualty versus Ryan, Price versus RLI, Oglesby, State Farm versus Ray, and said, if there's this kind of an assignment, the insured doesn't own the claim anymore. So we have a pleading that says, we signed this assignment, we think it's illegal, we get to sue on it. And based on those allegations, the factual allegations, this is not a viable cause of action and had to be dismissed. And the fact that there was a legal assertion in there that contradicted the plain language and legal import of that assignment of benefits does not rescue it. So the only allegation about the whole allegation about illegality that this entity was unlicensed was eliminated when count 2 was dismissed. And in fact, the trial judge even pointed that out. As far as the joint check goes, making a payment under an insurance policy has never been a waiver of a defense like standing.
To the merits of that, is it your position that that issue was not preserved for
Yes.
review?
Right,
And-
it was not preserved.
There was I guess, a reply argument that this court can overlook, the failure to preserve in rare and unusual circumstances, I think was the language. What is your response to that argument?
This is not a rare or unusual circumstance. And, if you want to argue waiver, you need to say the word waiver. And if we start, if this case is an exception, then every case is an exception to the waiver, to the rule. I mean, and this gets back to sort of the larger picture here. This is not going to do some grave injustice. As the trial court pointed out, all you need to do is file a new lawsuit. You now have extricated yourself from this controversy with Gulf. You have your release. Why not file a separate new lawsuit? So, I can understand a court looking past the preservation argument if some sort of manifest injustice is going to be done. That's not the case here. What happened is that State Farm gave a check to both parties so both parties could litigate their problem, did not want to become embroiled in their controversy, and essentially did the right thing. So then they get sued and they're confronted with a lawsuit that does not state a cause of action. There's no waiver. The waiver was never argued in the lower court, rightfully so, because look at it this way. Under Florida law, if an insurance company makes a payment, let's say they pay the wrong party mistakenly, and then they get sued by that party, they can argue a lack of standing. And in fact, insurance companies that make a payment to somebody who doesn't deserve it have actions for restitution. So that's why the briefs in this case do not contain a single case that says, insurance company, if you pay somebody money that may not be owed, that you can they're forever insured under your policy. You waived any right to point out, wow, these people really did not, they were not entitled to this money. And in fact, this mechanism of putting both parties on the check has actually been approved as an alternative to interpleader. The third DCA, there's a case, Geico versus Gonzalez, Margiotta, Kratz. There's a line of cases where it says an insurance company that's faced with this position can do one of two things. It is free to and may be obligated to put both parties on the check or file an interpleader. And actually putting both parties on the check is better for the insured, because if the insured is in a squabble like this one with Gulf and they get a check from both, they can then work out that dispute. If the insurance company files an interpleader, which they're not obligated to do, then the insurance company can get fees. So it imposes litigation, which everyone would rather avoid. And had the insureds worked this out with Gulf like they ultimately did, and then come to State Farm, the whole thing might have been, any controversy involving State Farm might have been avoided. But getting back to this case, we don't even go down that path, because in this case, I'm now going to exercise the discipline that the trial judge did. We have a claim we have an assignment that assigned away that claim, that needs to be dismissed. And as far as an amendment, I would also point out that the argument on appeal here today is that the court erred because the complaint below stated a cause of action. It does not. There is not an argument in the briefs before this court that the court erred by not allowing an amendment. All right, there's no, issue 2 on this appeal. The appeal is the trial judge made a mistake by finding that this pleading did not state a cause of action. The trial court was right, and therefore this needs to be affirmed. Even if, and I will now depart from the record just because of Judge Evander's question that really I think relates to the Boatwright case, which I know Your Honor wrote. If you then look at the futility of an amendment, if you look at the assignment of benefits and the scope of work, it talks about roofing, it talks about siding and gutters and all those and other things as well. And in Boatwright, they tried to invalidate that, and both of those cases involved unlicensed contractors trying to enforce the contract. That's not obviously not what we have here, but there is an insight in that case, and that is that if there's other consideration, then the contract is still enforceable. So if this had been pled a different way, there may have been an argument that, well, is this still enforceable even if they're unlicensed? And I think that's a legitimate argument, and probably Boatwright would help. But for the purpose of this appeal today, the trial judge was confronted with a pleading that tried to state a cause of action based on an assignment that was attached to the complaint that as a matter of law is enforceable in Florida, and the decision to dismiss the complaint was proper and should be affirmed.
Okay, thank you.
Thank you.
Rebuttal.
Yes, thank you, Your Honors. Insurer has still failed to provide any authority for the trial court to have gone beyond the allegations contained in the amended complaint. The assignment does not contradict the allegation that it's invalid. If we consider any other agreement that somebody could bring a suit on, say it was a prenup, somebody says this prenup is invalid, attaches the prenup. A judge isn't going to dismiss it and say you can't sue now.
Can you respond to the hypothetical opposing counsel gave that if you did a contract and said, I sold cocaine for this amount and the person hasn't fully paid me and this is a valid contract, could the judge look behind that and say, no, just because you said it's a valid contract, it's illegal and unenforceable as a matter of law?
I mean, I don't think that is on point to the issue here. We allege that it was
Well, the
invalid.
issue here is you're saying that you alleged it was invalid, but don't you also have to allege facts that would support that conclusion?
And I
Just
think
like
that's,
the cocaine example, you'd have to allege facts beyond the assertion that it was valid.
I think that goes back to the proper course would have been for leave to amend. Going back to the prenup example, a judge wouldn't have dismissed it and said, I don't care if your prenup's invalid. They would have said, amend and tell me why the prenup is invalid.
Is that raised as an issue in this case, that the trial judge erred, not given an opportunity to amend,
That was raised at the hearing, yes.
but not on appeal?
Well, the issue here is improperly stated by insurer. The issue is that they dismissed, not they dismissed without leave to amend, it's they dismissed, it's their order dismissing that's on appeal. They dismissed because they went beyond the four corners of the amended complaint. Additionally, I would like to point out that all of the cases cited by insurer all deal with valid assignments. They haven't cited to a case where an invalid assignment all of a sudden transfers all of the rights under a policy. And to insurer's point of putting both parties on the check, you brought up interpleading. That's what they could have done. That's what they should have done. Insurer should have interpled the funds, left the money with the court, stepped back, said, I don't know what's right or what's wrong, here's the money. They didn't do that. They've never remitted payment. The money's been sitting in State Farm's bank account, accruing interest this whole time. And homeowner's roof is still leaking. It still hasn't been fixed. That's what they should have done. And as far as the standing waiver argument, insurers stated that it's not a rare, unusual circumstance, but they haven't given any authority for that.
There's also no authority that we reverse and on the basis of rare and unusual or rare and exceptional. I can't even remember what the language is. Circumstances. It isn't our standard that unless it's preserved, we don't reverse unless there's fundamental error, and that hasn't been argued or evaluated in this case.
Well, the fundamental error is going beyond the allegations contained in the amended complaint. And I just wanted to
It's the appellate standard for considering an issue that has not been raised or was not preserved for appeal. Not going beyond the complaint, it's an appellate standard.
right. I don't think I understand.
That's my question, isn't it? That it's not rare and unusual circumstances. It's a fundamental error issue, which has not been presented in this appeal. The argument of fundamental error and whether fundamental error occurred in this case has not been addressed in the briefs here.
Okay, I understand. Yes, we didn't specifically address that, but I think it goes, I mean, I don't think that the argument was waived. Within paragraph 18 of our amended complaint, we stated that the check was issued jointly. If they wanted us to say that further, again, it should have been leave to amend. I mean, this all goes back to what was contained within the four corners of the amended complaint. What was contained was the allegation of an invalid assignment of benefits. That assignment was attached. Compared to any other contract in the world, this case would have not been dismissed. The only way to get past that is to make a finding of fact outside those allegations to determine that that assignment is valid. And that was an error. The trial court should not have done that. And for those reasons, we're asking this court to reverse the lower court's decision and remand this case, direct the insurer to file an answer. Thank you,
Okay,
Your Honor.
thank you both.
you.
We'll be in recess.